On 23 January 2023, the Commission sent you a request for submission of the 5-year declaration of assets and personal interests. On 30 January 2023, you submitted your 5-year declaration. The Commission also asked candidates to voluntarily complete and submit an ethics questionnaire, and you did so on 5 July last year, 2022. The Commission sent you 3 rounds of questions on 21st of March, 31st of March, and 6th of April 2023, respectively. You were asked a total number of 18 questions, including 45 subparts, and 18 of the questions included a request for further documentation. According to Article 3, Paragraph 4 of the evaluation rules of the Commission, a candidate may not provide information, documents, or other materials during the hearing if the Commission requested these earlier and the candidate did not provide them within the time specified, unless the candidate provides sufficient justification for not providing the information as requested. Pursuant to Article 12 of Law No. 26/2022, the hearings shall take place in a public session. The Commission may, however, decide to conduct a part of the hearings in a closed meeting if the interests of public order, privacy, or morality are undermined. Yesterday afternoon, the Commission received a request by you pursuant to Article 12, Paragraph 2 of Law No. 26/2023 and Article 3, Paragraph 2 of the Evaluation Rules to hold a part of the hearings today in a closed meeting. Your request related to 2 issues. Pursuant to Article 3, Paragraph 2 of the Evaluation Rules, the Commission will decide upon such a request with a reasoned decision. The following comments serve to provide you with this reasoned decision in an oral format today. A written decision will be issued to you in the course of next week. The first issue you requested to be heard in a closed meeting is an issue that the Commission has decided not to discuss with you in the hearing at all. The Commission therefore does not have to discuss the merits of this request in this oral reasoned decision. The second issue you requested to be heard in a closed meeting touches upon the right of ownership of an apartment. You requested for a closed meeting as litigation in relation to the ownership of this apartment is still ongoing, and that you believe that, and I quote, "the Commission's questions and the undersigned answers may harm both the examination of the case and the rights of me and my wife as parties to the trial," end of quote. You also asked the Commission, beginning of quote, "in order to avoid harm to the interests related to the private life of the Codreanu family during the hearing, not to disclose the factual grounds invoked in this request," end of quote. The Commission first observes that your request was filed with the Commission in an untimely fashion. Pursuant to Article 3, Paragraph 2 of the Evaluation Rules, a candidate shall, within 2 days from the invitation to participate in the public hearing, submit a reasoned request for an in-camera hearing as per Article 12, Paragraph 2 of Law No. 26/2022. You received the invitation for the hearing on April 13, but your request was only submitted to the Commission yesterday, April 20. The Commission notes that questions relating to the ownership of this apartment in Chisinau have been addressed to you in both the first and second round of questions, so you have been aware of the Commission's questions about this matter since 21 March 2023. Notwithstanding the untimely submission, the Commission has also decided to provide a reasoned decision based on the merits of your request. The Commission notes that the litigation relating to the ownership of this apartment are of a civil nature and not of a criminal nature. So the possible risk of self-incrimination does not arise in this context. The proceedings and all related appeals are all public, and in a most recent decision in this pending litigation, your name and the name of your wife are not anonymized, but the address of the property is anonymized. In the public hearing today, also the Commission will not refer to the address of the property. The Commission also notes that you do not provide any further explanations to your statement that the questions by the Commission and your answers to these questions may harm both the examination of the case and the rights of you and your wife as parties to this litigation. The Commission concludes that it is not convinced that the interests of public order, privacy or morality are undermined if the discussion relating to the ownership of this apartment is discussed in a public hearing. Therefore, the Commission rejects your request to hold a part of the hearings today in a closed meeting, both on the ground of late submission and on the ground of the merits of your request. Pursuant to Article 12 of Law Number 26/2022, and I quote, if the Evaluation Commission rejects the candidate's request to hold the hearings or part of them in a closed meeting, he or she may immediately notify the Commission of his/her withdrawal from the competition. End of quote. I therefore ask you if, based on the Commission's decisions rejecting your request for a partly closed meeting, you would consider to withdraw from the evaluation. In case you would require some time to reflect upon this issue and maybe seek advice or consult another person, the Commission, of course, is willing to briefly interrupt the hearing for 15 minutes to provide you the opportunity to decide whether or not to notify the Commission of your withdrawal. So my question to you is whether or not, based on this decision, you would like to continue with the evaluation or would like to withdraw from the process.
No, I insist that we continue the evaluation. I have no objection. I think that this decision is well reasoned.
Thank you very much. And as I mentioned, we will send you the written version of this decision in the course of next week. Also, I have to mention that yesterday you submitted various other documents to the Commission. The Commission hereby acknowledges a receipt of these documents, but they have so far not been translated and studied by the Commission, and the Commission will therefore determine at a later stage whether or not to consider these documents in the evaluation. We will continue with the standard script for the hearings, and therefore say that the members of the Commission will now start with asking you questions, and Victoria Henley will start with asking questions. Again, we will try to keep our questions short and to the point, and we ask that your answers be short and to the point as well. Victoria, you have the floor.
Good morning. And I may have missed this in your introductory remarks. When did you begin working as a prosecutor in the Anti-Corruption Unit?
July 2016 is when I started.
Thank you. And to begin, I'm going to read some facts and then ask you some questions. And the issue I'm going to begin with, which I believe you've been provided a copy of, has to do with the method of acquiring service-based housing and privatization of that housing. You and your wife own a 49.1 square meter apartment located in Chisinau, based on a certificate of ownership of a share of common property dated 17 March 2016. In 2009, you applied to the City Hall of the Municipality of Chisinau with a request to be provided with housing pursuant to Article 38 of the Law on the Prosecutor's Office. Your request was initially denied. You appealed that decision, and the Administrative Court of the Chisinau Court of Appeal ultimately decided on 9 April 2009 that the Chisinau Municipal Council was obliged to provide you with housing space. In 2014, you submitted a request to declare the 49.1 square meter apartment located in Chisinau as vacant inheritance, to have it transferred to state property, and to have it allocated to you to fulfill the 9 April 2009 decision of the Chisinau Court of Appeal that the Chisinau Municipal Council was obliged to provide you with housing space. Your arguments for declaring the property vacant were that the owner of the apartment had died in 1994 and no succession procedure was opened after her death. The apartment was declared vacant, successional patrimony, and the Chisinau Municipal Council was obliged to issue a distribution order to you for installation in the apartment by the decision of the Chisinau Court, Riscon Office of 31 July 2014. Both the Court of Appeal and the Supreme Court of Justice rejected appeals of that decision. By distribution order of 7 December 2015, issued by Chisinau City Hall, the right to settle in the apartment was offered to you and your family. The apartment was privatized by your wife in 2016, not on the basis of a judicial decision, but based on the decision of the Privatization Commission of 15 January 2016. By contract of sale, purchase dated 16 March 2016 between the Chisinau Municipal Council and you, the apartment was transferred to you and your wife as private property. The contract was concluded by your wife, who represented you through a power of attorney. Neither you or any of your family members have lived in this apartment, which you have stated was because its condition does not allow living there with children. I will begin by asking you some questions to establish the facts. Hopefully these can be answered with a yes or no response. Later I'll ask you some questions that will seek greater detail or explanations from you. Please confirm that you and your wife own a 49.1 square meter apartment located in Chisinau, based on a certificate of ownership of a share of common property dated March 17, 2016.
Yes, that is correct.
And please confirm that in 2009, you applied to the City Hall of the Municipality of Chisinau with a request to be provided with service housing pursuant to Article 38 of the law on the Prosecutor's Office.
Yes, that is correct.
And that was a request for service-based housing, correct?
Exactly.
And your request was initially denied, which you appealed, and the Administrative Court of the Chisinau Court of Appeal ultimately decided on 9 April 2009 that the Chisinau Municipal Council was obliged to provide you with housing space.
Exactly.
And so that decision by the Court of Appeal was that the Chisinau Municipal Council was to provide you with service-based housing, correct? Okay.
Exactly.
Pursuant to the law on prosecutors, the law on housing for prosecutors.
Conform legii per la procuratură, da.
Exactly, with regards to, on the basis of that law, and that was practically the law that was referred to in practically all decisions in 2009 and in 2014 decisions. In the 2014 decision, it was only referred to, so the 2009 decision was referred to, which was argued through the lens of Article 38 of the law of the Prosecutor's Office.
And please confirm that you served as a prosecutor in the Riscon Prosecutor's Office between 2003 and 2011.
Exactly.
And please confirm that in 2014, you submitted a request to declare the 49.1 square meter apartment located in Chisinau as vacant inheritance and to have the property transferred to state property.
Exactly.
Your arguments were that the owner of the apartment had died in 1994 and no succession procedure was opened after her death.
Exactly.
And your request also sought to have the property allocated to you to fulfill the 9 April 2009 decision of the Court of Appeal that the Chisinau Municipal Council was obliged to provide you with housing.
Exactly. That is true.
And is it correct that, I believe you claim that you found out about the property from an acquaintance during a discussion that took place in 2014.
It is true, and I provided this information to Ziarul de Gardă, a newspaper, as well. When the first publications about this apartment happened, there had been questions, and I answered, and I told them that I found out about this apartment in 2014 from an acquaintance, who I think was a lawyer, if I'm not mistaken, at that time.
Okay. Can you tell us who was that person and exactly what did that person tell you about the property?
I don't know the precise name. Only his, not his last name. I only know his first name. We just had some common acquaintances, but I had almost no relationship with him, only like saying hello when we meet on the street. In a discussion with him, I don't remember exactly, but I believe so, in a discussion with him, I told him about the fact that, I have a court decision of 2009. I asked for enforcement. The bailiffs cannot enforce because the city hall does not have any dwelling to allocate. And then he told me that I know about an apartment. The owner died back in 1994. In relation to this, I discussed with a lawyer. I asked him to check this matter. From what I know, that lawyer had access to the database of the cadastral office, and he told me that indeed this information is confirmed, the information that I told him. I asked, can I do something about it, act somehow in court? He told me, yes, I can prepare your documents. So he prepared the application, I filed it, it was registered, the proceeding was like in any other court. So it was registered, we were called to a court hearing. So, well, I was not there. Personally, the lawyer was representing me, and I would like to tell the Commission that during the court investigation, the defense attorney made a request. Well, they notified the Ministry of Justice to check if in the register of heirs, I don't know exactly the name of that register, but they asked to check if there is any succession or inheritance related to that real estate. And during the proceedings, this document was submitted to the court, so it was found that the deceased had no one to inherit her, and she did not have any will on any other person.
Okay. Before you initiated the lawsuit, could you describe what steps you undertook before you submitted a request to have the property declared vacant to determine that the property was vacant? Did you check the cadastre, for example, to see the ownership history of the apartment?
It was not me who checked. I did not have access to the cadastre. The lawyer did. The lawyer who actually started this proceeding, he drafted the application, he attached my and my wife's identity documents. I think something about the state fee. So the steps were the ones that I already said, starting from the person who told me the information and up to the decision that was issued. So I did not do anything else. I could not actually do anything else. I only went to a lawyer and I said that there is an apartment, the owner of which died, and asked him to check it and draft an application to court for me.
Okay. You, before instituting the proceedings, you did not check court records to see whether any succession procedure had been opened after the death of the owner, of the person who was listed as owner of the apartment.
Eu am comunicat.
just told you. I did not have any other levers or methods except for the situation when the proceeding was going on during that court investigation of the application that I and my wife started. I may be wrong, but the lawyer asked the court to ask the Ministry of Justice to check in the register to see if there is any succession mentioned, or the lawyer did it on his own and then he filed it as evidence. So this piece of evidence is part of that civil proceeding, meaning that that letter was submitted to court by the Ministry of Justice that stated clear that there is no succession about that apartment. Otherwise, it wouldn't be possible for me to act further on. Otherwise, I would have given up on that litigation to continue the proceedings, because it wouldn't make any sense if there was any succession or heir registered somewhere, or generally if, as a matter of principle, there were any relatives of that person. It would not make any sense. It would not make any sense to go into a lawsuit with someone for an apartment with someone who has right to it or claims to it.
Did you contact the association that manages the block that the apartment was in to see if payments had been made or were being made for communal services for the apartment?
No, I want to explain. After the first level court issued a decision 2014, Rashkani court issued, I will tell you in sequence so that you can understand when I found out about certain circumstances regarding the people who were living there. After the decision was issued, it was appealed by the municipal council and by the tax inspectorate. It was appealed up to the Supreme Court of Justice, and this decision became final and irrevocable. And when it became final, I went to the General Department for Exploitation of Housing Stock, and that department told me, actually it was not me, the bailiff did, in order to enforce the procedure, because there was a writ of enforcement by that time. So in order to enforce the procedure, he went to the department, and the department told him, we cannot do anything because this apartment is not the property or is not managed by the department, because the court said that the apartment should become property of the state and then transferred to the local public authority. And in these circumstances, a set of documents was submitted to the Department of Housing Stock. The department asked for information from the State Tax Inspectorate, and the State Tax Inspectorate, based on that decision, which I reiterate was final and irrevocable, drafted a document or minutes of transferring the property from state property to local public authority property. Subsequently, after this minutes or report was signed, the General Department for Housing Stock asked for a set of documents so that this distribution process could be documented and the apartment to be transferred to me. And during that specific procedure, when I submitted the documentation, the Housing Stock Department asked the association that was managing that block of apartments. It was CCL 82, I think.
82.
So it was the manager, let's say, the manager of that block. So they made a request towards the president of that fund, asking documents about who was living in that apartment on the day of the request. That information was written by hand by the President and was submitted to the department, whereby it was informed that no person lived in that apartment. At the same time, based on this information and documents that I submitted, if I'm not mistaken, in 2015, the order of distribution of property to me was given to me, and with that distribution or assignment order, in order to be able to start to use the apartment, the bailiff went to that address and found that on that address there are certain people who are living there. But those people were the ones who were renting that apartment from other people who claimed to be owners and with whom I'm still having a litigation until today. And I provided the Commission with the decision of Chisinau Court Central Office, which rejected that request to cancel, to annul the distribution order and recognition of ownership rights. So that in that situation, the apartment was transferred to me, and that was, all these actions were happening like in a sequence, one after another. I notified the Privatization Commission, which also asked for a set of documents from me. I submitted them, and after some time I was informed that there is a draft contract for sale purchase. We have to go to the notary and sign it, and this is how we concluded the procedure.
Okay. If I could ask you quickly about the statement that you referred to, the handwritten statement of the president of the HCC 82 Association. Did you have any contact with the president about that statement?
To explain, and a question about this and the publications that were made and that I submitted to the Commission, it was invoked that I came to the President of the Commission and gave him that request, and that is true, in order to speed up this procedure. The head of the housing department said that I can either send it by mail or I can give it to you physically, and that you can go and register it with the president of that association, and in order to get the answer as soon as possible. So I went to that address, to the president. I gave him that document. I did not tell him who I was, what my position was, that in the press release or in the publication that I said that I introduced myself as I don't know who, but that is absolutely untrue. And there was a service inquiry about me, and in that respect, and I provided the Commission with a decision of the prosecutor's inspection of 2018 that did not find any violation committed by me generally in relation to acquiring the right of ownership regarding that apartment. So, on the same day, the President gave me that answer, which is stamped and written by hand. I provided it to the Housing Department, and that's how the procedure was closed.
Okay, and when you spoke with the President, did you speak with the President in Russian or in Romanian?
I spoke Russian, because I saw that the lady did not have a good command of Romanian. So she spoke Russian, and I have no issue. If someone speaks Russian to me, I answer Russian, because I speak Russian well.
The handwritten statement that she prepared was done in your presence, correct?
I don't recall precisely. I know where I went. I went to her, but I do not remember if it was written in my presence. Maybe yes, but I cannot certainly confirm that. This happened on the same day. When I came to her, on the same day, she issued me this document. On the investigation that was carried out by certain alleged or pseudo-journalists, it results that the lady believed or perceived that I was a person from the city hall. But I did not introduce myself in any way.
But you went to her,
Exact.
a document
Yes.
was prepared, and you left with that document. You didn't make more than one trip to her during that day.
O singură călătorie.
It was one trip. But I just want to make a comment. This issue is also in the publication that I shared with you. This was after working hours, and I called her and I asked her, esteemed lady, where can I find you to give you this request from the department? And she told me, I have a part-time job, I work at a market, and if you can come there, it's all right. I went to the place that she told me to. I picked her and I brought her to the building. Her office is a little tiny room in that block of apartments. And I explained her from the beginning why I was coming. I gave her that request. At that time she told me to wait. She wrote that answer and she gave it to me. That's it. I did not have any other discussion with that lady, but from the publication, some other things showing.
Did you discuss with her what the statement should say? What should be in
Nu,
this?
categoric.
No, categorically not. And I could not use my influence, somehow convince that person. No, that's false, that's untrue, certainly.
So if the document, however, is in Romanian, correct?
Eu nu pot să vă spun.
I can't say what language. I can check, but I don't exclude it. Maybe in Romanian. If I may, I probably have it.
Yes, and we furnished you a copy with it again this morning.
Azi dimineață?
Today in the morning?
Yes. There's a copy of it.
Nu, azi dimineața nu, scuze, dar astăzi dimineața am primit.
Sorry, today in the morning I only received the issues. Sorry, I don't hear what someone says. Okay, if I may. Yes, I identify. Yes, that's the document. And it is in Romanian, indeed.
So if she didn't speak Russian, how did it come to pass that the document is in Russian if you didn't discuss with her the document's in Romanian, if there was no discussion?
Chiar nu am o explicație.
I have no explanation. I just presume that given that the request was in Romanian from an authority, she probably believed and she probably could write and she understood what she was writing or what is written. This is her handwriting. This text was not dictated by anyone or by me, if you try to claim that. This text was not suggested to her like what she should write.
Was anybody else present during your meeting with her?
Nu.
No. No one was there. It was only her. As I told you, it was after 5.
Okay, and I just want to confirm that the apartment was declared vacant successional patrimony, and it was also determined that the Chișinău Municipal Council was obliged to issue a distribution order to you for installation in the apartment by the decision of the Chișinău Court Riscan Office of 31 July 2014.
Exact, și acest ordin
Yes, and it was issued.
și în baza acestui
Based on that order, all other procedures were carried out: privatization, sale purchase contract, evacuation or eviction, of the people, and even that eviction was appealed. That was another litigation in another court. That also was the eviction was considered by court, and it was appealed by the part that claimed to be owner, and the Supreme Court rejected. Well, it was appealed. The first level court rejected, and the Court of Appeal also rejected the challenge. So that's how it was.
Summons to have the apartment declared vacant, you relied on the provisions of Article 1515, Paragraph 1 of the Civil Code regarding the way of recording, valuation, and sale of vacant properties by the state, correct?
Da, probabil.
Yes, probably so.
Dacă e necesar.
I have the litigation, but I believe that what you're saying is true.
But isn't it a public authority that has the competence to file applications in court to have property declared vacant and transferred to the state?
Am înțeles întrebarea.
I didn't understand the question, please.
Isn't it typically an authority such as Fiscal Service that has the competence to file applications in court to have property declared vacant and transferred to the state? My question is what authority you had as an individual to file an application to have property declared vacant and transferred to the state?
I am not sure if the state tax service knew about the fact that the person or the owner of that apartment was deceased. The tax authority could not know. And did I have the authority or possibility? I don't understand what to do for me to notify the tax authority so that the tax authority to avoid the litigation in court, or the tax authority to do.
Notified the tax authority that the property was vacant, correct? And then the tax authority would have.
Nu e așa, deoarece
It's not like that, because the procedure allowed me to notify the court directly. And I want to tell you that in all cases, such litigations during the years 2003, 2009, or even 2010, until the law on prosecutors had these provisions that allowed or were obliging to give prosecutors service housing. Before that, the procedure was identical for everyone. The person who found an apartment notified the court, and the court, in its turn, decided to declare vacant succession. The procedure was different depending from a case to another, but generally it was a procedure. I could not even believe that I can notify from the beginning the state tax service. And in that situation, I could not have guarantees that the state tax service would accept and enforce that request, and that the state tax service would take measures for that apartment to be assigned to me as provided by the court decision of 2009. That's why I chose to go directly to court.
And just to make sure I understand, it's your position that Article 1515 of the Civil Code gave you the right as a private citizen to petition the court to have property declared vacant. Is that correct?
I believe, yes, including that apartment, not only that one, also the law on prosecutor's office, also the general provisions of the civil code, all of them altogether. I can't say that that provision specifically, or that provision is exhaustive and comprehensive, and I relied only on it.
Article 1515 of the Civil Code provides that the state takes possession of the estate by issuing a certificate of vacant succession, The certificate of vacant succession is carried out by a notary who establishes that there are no testamentary or legal successors, and as a result issues the certificate of vacant succession, and the patrimony passes to the management of the state. The process of having a certificate of vacant succession carried out by a notary did not happen in this case, did it?
It's not like that. Well, it did not, because there was a court decision in this case. That's what I'm trying to explain. I went through a litigation procedure. I did not follow the procedure of going to the tax authority, and I was not obliged to do that by notifying the state tax service. I chose to follow the way of starting a civil litigation in court, and if the court believed that my request was inappropriate or did not fit the provisions that you just mentioned, they could have rejected my request. And I want to be understood. That request and that decision was supported up to the Supreme Court of Justice, including through extraordinary appeal methods that were used by the alleged owners. I cannot say if I had the possibility to act in another way than going to court. The court, I don't know, if this was non-compliant with the law, the court would have rejected my request. That's what I believe. But as long as that decision exists and it is final, irrevocable, and it went through all levels of national courts, I believe that I proceeded differently than... I don't think that I proceeded differently or in ill faith or circumventing legal provisions.
But because there was no certificate of vacant succession carried out by a notary during your litigation, the attempt to determine if there are any successors to the property was limited to the Ministry of Justice doing a review to see if any succession had been filed, correct?
Indeed, but that was the only legal procedure and accurate procedure to ascertain that there is no succession registered in that, recorded in that register with respect to that real estate. Only that. And I was not in the court hearing because I was represented by the lawyer, and generally I knew what was happening, and that the request was coordinated with me, but he or she actually knew better. She undertook those actions and the court accepted, and I want to draw your attention that the court in its decision made reference to that document as a means of evidence, of proof that was underlying the decision.
Since you were represented by counsel in those proceedings, why did you personally contact the president of the HCC 82 Association rather than having your attorney do it?
I explained. My counsel had proxy, well, was authorized only for the litigation in court, civil litigation in court. That matter with the certificate that Madam Topova issued, the president of the association, number 82, was outside the civil litigation because the litigation had already had a final and irrevocable decision by that time. Again, it went through all levels of courts. In this case, the attorney could not be involved. In a way, I was supposed to pay her differently or conclude another contract with her because it was already beyond the court proceedings.
If you got me right. That certificate was issued after the court decisions were pronounced. My counsel had the mandate, the powers to act in the civil case in court only. in all of the courts, not outside the courts. Or at least not as far as communication is concerned, communication with the institutions of the local public administration, such as the Privatization Commission or the Housing Department. In that regard, I was the one responsible of submitting documents as requested by the department, by the Privatization Commission, not the council. It was not up to the council to do that. I did not assign the council those tasks. They were, the council's duties were only related to the civil litigation in courts.
And by distribution order of 7 December 2015, issued by the Chisinau City Hall in response to court orders, the right to settle in the apartment was extended to you and your family, correct?
Exactly.
And please confirm that the apartment was privatized by your wife and daughter in 2016 based on the decision of the Privatization Commission, decision of 15 January 2016.
That is correct. And in this regard, I would like to add that the Commission, in the first and in the second round, no, actually in the second round of questions, the Commission asked me to submit a copy of the decision of the Commission. And I received it through the Secretariat of the Anticorruption Prosecutor's Office, because all my requests and inquiries with regards to the preventing process, I did all of those through the Secretariat. And this information that I sought, I only received yesterday an answer to what I was seeking. And it's yesterday that I received the information, or that, well, not information, specifically that excerpt, that decision of that decision. And yesterday I submitted it to the Commission just to clarify the fact that I tried to do my best to do things in due time, but it took longer. And my first request, my first inquiry with regards to the decision and with regards to the documentation that underpinned that decision were made in March of the first round of questions. That's when I sought it. And the Commission people, they told me that they can give me the documents, but not the decision, because the decision had to be signed off by the Deputy Mayor, and the Deputy Mayor was away on a business trip, and he couldn't sign it. It's only yesterday that they sent me that document. And I also submitted, I've actually also sought, after the second round of questions, the Privatization Commission. I also asked them about that question that the Commission asked me, what were the legal grounds. And it's yesterday that I received, or actually not, on the 12th, I received the document from the Privatization Commission, and I submitted it with regards to the grounds for that decision being adopted. And if I may mention still in this regard that the Commission, upon my first request, the Commission told me that that decision was not challenged, hadn't been challenged, and it was still enforced to this day.
Why was the apartment privatized by your wife and daughter and not by, why were you not included in the request for privatization?
Let me explain. When I went to the Privatization Commission, they told me that I needed to submit a set of documents. And among those documents, one of the certificates that I was supposed to submit was a certificate that ascertained whether I and my wife, or my wife, participated previously in the privatization of any other property. And I submitted that document from the housing department of where I used to live with my parents. So there's a document that when I was a child, together with my parents, that we all participated in a privatization process back when I was a child. And given that I had participated in that, but that privatization back then, that it was happening around 1995, 1994. I was a minor back then. So it was sort of against my will, or without me being knowledgeable about it. I mean, back in 1991, they would issue some sort of documents, and my parents would get them at their workplace, and on the basis of those documents, they would be able to privatize certain assets. So involuntarily, I participated in that privatization process. And given that, I was not able then to participate in privatizing this apartment.
Right.
But in order for me to be able and to settle in that apartment and to have a legally acquired property, but my wife at that time, because I submitted that certificate to the commission, at that time she hadn't been concerned in any privatization process, and thus my wife and the child, who was born in 2015 and never participated in any other participation process, they privatized the apartment. They had the right to privatize that apartment.
As to the earlier privatization of the apartment, you did become a one-quarter owner, and you're still a one-quarter owner of that apartment, correct?
Probabil că da.
I guess so. As for these shares, one owns in an apartment. I don't know how exactly they are distributed, but it's 4 members of our family: myself, my sister, mother, and father. And those shares, I guess, there were equal shares to all of us. So maybe it's a 0.25 for each of us. But I am not 100% sure about it. I don't know the details of it. I did not participate in that procedure back then. So I don't even know where a decision in that regard is and how all that procedure was conducted. I don't know those details.
And just to confirm, by contract of sale purchase dated 16 March 2016 between the Chisinau Municipal Council and you, the apartment was transferred to you and your wife as private property. Is that correct?
Exact.
Exactly.
Okay, according to Article 5, Subpart 2 of the Law on Privatization, 1324/1993, real estate located in certain areas can be privatized, and the statute notes, with the exception of service housing, can be transferred within the limits of the rules of the law to private ownership. Do you agree that that law, 1324/1993, prohibits privatization of service-based housing?
Eu, ca prin surprindere, atunci când am primit
Well, surprisingly, at the time when I received the first or the second round of questions, I looked back into the law, and I also looked into the decision of the Constitutional Court of 2016 with regards to this matter. And to me, I would like to say I was surprised to see that the provisions of the law, but I think it was Article 19, if I'm not mistaken, or 17, maybe even, of the law on privatization. And indeed, there is a provision, an exhaustive provision, that stipulates that service housing, there is an exception there from privatization, and that applies to service housing. I was not aware of it. And at that time, and actually that's what I answered in the first round of questions, I provided also information in regards to that. I said when I was preparing the documentation and when I informed the Privatization Commission, I was not aware of that, and I hadn't even looked into the details of it. I did not thoroughly examine it because I thought I was going to submit the documentation and that would be it. That's what I thought, and that's what I did. I submitted the set of documentation, and next then I was informed that there was a decision of the Privatization Commission, and in the Q&A rounds I said that I informed a public authority, and it was not my remit to establish whether I met the privatization conditions or not, or any other conditions. Did I meet any criteria or not? That was not up to me. It was in the remit of that commission to assess whether I met them or not. So I can't, I just informed and notified the commission. I applied with that commission. If the commission would have said no, then that would have been the end of it about this department, I believe. So I'm not assigning to myself any illegal action, or the way it was worded in the question as in unethical, because as any other citizen, albeit I was a prosecutor who is supposed to be very knowledgeable of the legal framework, I filed an application with an institution. I have the right to do that. Now, the decision made by that institution is not in my remit, it's not up to me, and it cannot be attributed to me, I believe, as a violation of ethics or as a violation of the law, or as a matter that can, in one way or another, be recorded as a violation of the ethics rules for prosecutors. But even as a civilian, I filed an application with an institution. I had the right to do that, to notify, to address an application to that institution. So I cannot assume responsibility for the decision that the Commission took. Why the Commission took that decision, I don't know. And I would like to also say that regarding that question, regarding that issue, that I looked into that and through the lens of the law, I thus wrote an inquiry with the Commission and I asked, what was the legal framework? Why did this even happen? How was this possible? How did this come to be? And they gave me an answer on about 2 pages. And by reading it, I still didn't come to a point where I could understand very well the position of the Commission.
But doesn't that document also cite the law and the exception that property can be privatized except service-based housing? It says that on the first page of that letter.
Yes, there is that reference is made, but that is not my problem. I think that might have been an error or some, but this is not my problem, as in I cannot take upon myself this responsibility for an act, for some sort of an action that was undertaken by a public authority. I have the right to go to that institution, to apply for something with an institution, but I cannot have responsibility for what that institution is doing. Cannot be a responsibility for that, or for how they decide, for how they make their decisions. What's important, and I think has to be taken into account, what is important is that I gave them all the documentation, I gave them all the information that they sought. I did not hide anything away. I did not hide away any circumstances whatsoever. I did not influence in any way any people at whatever stage of the process. I just exercised a right to go to an institution, to apply there.
And do you recall whether you submitted to the privatization committee your request for service-based housing? Your application for service-based housing.
I submitted the court decision. The court decision contained the explanations, and it said clearly that that is state-owned property. It's property owned by the government. That then by a document was transferred over to the mayoralty, and then the mayoralty gave me that asset. I presented all that documentation. I think it was 4 documents I was supposed to submit, and I submitted to the commission, to the privatization commission. I submitted to the evaluation commission what the privatization commission told me as a response to my request, to my application. Everything is there. Nothing was hidden away.
Okay.
And I would also like to explain that when it comes to the first stage of evaluation of the documentation that I submitted, it was not the Commission, but there was the Department General for Housing. So that was supposed to be the buffer, the filter that was supposed to look into the status documentation. They were also submitted that decision of the court. They were supposed to verify that and draw up a order of distribution, and it should have also said that it's a, for instance, service housing, because the error and all the problem that the Commission is looking at, it emerged from that order of distribution of the asset. Because that distribution order, it didn't say, I mean, I can just imagine, I think maybe that if that word would have been there, then maybe the privatization commission wouldn't have accepted my documentation, my application at all. But that is a conclusion that I cannot now substantiate on the basis of the law, but it's like a logical deduction that I could draw. And in fact, now having had discussions recently with members of that commission that were given me gave me the answer for me to have a clearer understanding, they told me, they said, "Dear sir, but in that allocation order, it didn't say that this was supposed to be service housing. It didn't have the service housing term there." So then I wonder, why is this responsibility, why the ethics responsibility, why are there any ethics questions addressed to me then, given this circumstance?
All right, and when the Commission first asked you about the legal basis for privatizing service-based housing, you stated that the law provided the right for a prosecutor to service housing and did not provide, the Commission noted that the law provided for the right of a prosecutor to service housing and did not provide for a prosecutor's right to privatize service housing but neither did it include any prevention of that.
Exact. Eu am
Precisely, I made that statement after the first round of question without having known the essence and the specificities of this issue that the Commission raised while my evaluation. I provided an explanation on the basis of the law in the prosecutor's office, because the law in the prosecutor's office did not prohibit privatizing, but in this case, the special law is the law on privatization, the one that applies. And then certainly the provisions of the law of privatization are essential. And this is a certain thing that I cannot pretend not understanding that, or I cannot try to provide any other explanation than the one that applies.
And then I believe in response to a second inquiry from the Commission about the law prohibiting the privatization of service-based housing, you stated that you didn't know what the legal basis was that would have allowed the privatization of the apartment, and that you only realized a right to address the Privatization Commission to verify the legality of the acts and the factual and legal grounds that would justify the admission of the application or its rejection. Is it correct?
exact.
Precisely. That's what I've been explaining so far today about that provision of the law on privatization. I've only found out about it while answering the questions coming from the Commission. I didn't even think I would find myself in such a situation where this sort of questions would be raised, would exist. I did not even think of it in my...
Okay, and when asked by the Commission whether you considered it ethical, I think you touched on some of this, to seek the privatization of service-based housing, you stated that you do not believe you violated in any way any prosecutorial ethics or conduct.
Exact.
Precisely.
That was checked by local public authorities and state institutions at various stages and times, correct?
Exact.
Precisely. When it comes to the questions of ethics, to these issues, I looked into the Ethics Code of the Prosecutors from 2016, approved by the Superior Council of Prosecutors, and I did not see there anywhere any remark through the lens of those issues that the Commission raised. So I did not see anything that would be in violation of, or that would leave sort of a footprint in terms of my ethical behavior, ethical conduct. And when it comes to the ethical rules, I've never had any issues.
There have been legal challenges made to your right of ownership on the property, correct? The apartment?
Exact.
Okay.
That is correct. A number of times, and different people, individuals, and legal entities as well.
And could you explain who's making those challenges and what is the status of the challenges?
I've explained it, but I will go over it again. There was the decision of 2014, and that was challenged by the accessory and by the defendant. I'm not sure if those were the statuses. But the municipal council challenged it with the appellate court and the tax service as well. And at the Supreme Court of Justice, it was only challenged by the municipal council with the Court of Justice. But then, when the evacuation came along, that decision of 2014 was challenged by an extraordinary remedy by the alleged owners. It was challenged, but that application of review was declared inadmissible. Then there was another procedure that I communicated already about regarding the eviction, and it has also been challenged, and it went all the way up to the Supreme Court of Justice, and the eviction was upheld.
And the challenges were filed by the wife of the former husband of the person who you believed was the owner of the property, correct?
Yes, she was the one who submitted it through her counsel, or her defenders.
And the children as well, correct?
I'm not sure about the children. The children, so there was the wife and the children, the mother and the children. They were the plaintiffs in the application, and there is a decision from 2022 that was rejected, and I submitted it. So that's what I know, that there has been some recent decision there. The 2014 decision as to whether the children or whoever was there who took any action, I cannot communicate any details about that as of now, but I submitted all those decisions that were ever adopted, and you can have a look at that. I mean, that can be looked at.
Did you ever inform the Chisinau Municipal Council or the courts that at the time that you applied for housing pursuant to Article 38 of the law in the prosecutor's office in 2009, that you had been in contract to buy a preferential priced apartment for prosecutors since May of 2008?
No, I did not communicate that information because that matter was no longer topical at the moment in time. The 2013 apartment that you referred to, and that was purchased for a preferential price, it was sold in 2013.
I'm asking you at the time that you applied in 2009 for service-based housing, whether you informed them that you had been in contract since 2008 for a preferentially priced apartment.
No, I did not inform them, but I am not sure that that contract was from 2008. I cannot be sure about it now. I know that the contract was registered with the cadastre in 2010.
I believe it should have been in the copies that were given to him today.
Da, ia mult timp să caut. Da,
Yes, 15th of May 2008, that's the date on the contract. But it was registered with the cadastre in 2010, and this handover document is 21st of December 2010. And with regards to this contract, yes, I did not inform the Chisinau mayoralty about it. I did not inform them about this agreement. And I believe I didn't have to, because the investments contract does not in any way. Well, I was speaking about the fact that I couldn't have had, I didn't, at that moment in time, I couldn't have said I had an apartment where I could have lived, and that according to the law, I could have called it a service housing.
But you'd entered into a contract to purchase preferential priced housing through the program to provide housing for prosecutors, correct?
Exact.
Right.
Since you were already taking advantage of one housing program for prosecutors, did you consider it ethical to apply for another housing benefit for prosecutors without telling them about the preferential priced apartment?
It was ethical, and I will explain why, and I provided explanations with regards to that in the second round of questions, because what you are saying intersects with what I said about the apartment from Basconslux. That apartment, to start with, was not meant to be mine, but it was meant for my sister. And I explained in the second round of questions that I exercised a right, and given that I didn't have the funds, the money to pay for that apartment, that was on the basis of the investments contract, because, well, living, as the sister was living with the parents, my sister was divorced, she had a child, a decision was made for that apartment to become hers. When I say this apartment, I mean the apartment that the investments contract was regarding, and that I received in 2010. From the very outset, I was not how should I put it, was not supposed to be the ultimate beneficial owner of that apartment. It was only an expression of intention, a contract that had effects, bared effects for my sister. And I explained I've never lived in that apartment. It was from the first day that my sister moved in there. She did all these interior renovation works, and I couldn't have lived there together with my sister. She had a child, and the apartment was a one-room apartment only.
And with respect to the 49.1 square meter apartment, neither you or any of your family members have ever lived in this apartment, correct?
Precisely, and I provided information in this regard. And if the Commission believes it's important to see those pictures, they show the condition of that apartment. And if you allow me to submit them, to present them to you, I have 6 pictures. Just this apartment, before I took it over, was in terrible conditions. It was not possible to live there. We already had a baby at that time, and when we looked at that apartment to see if we could move in, my wife refused to enter with a child there because the condition the apartment was in, if I may present these pictures to you, if you accept to have a look at these pictures, was not possible for one to live there.
We'll accept them, and the Commission will later determine whether to consider them in the evaluation. Thank you. Is there anything you wish to add or clarify with respect to this issue on the 49.1 meter apartment?
Eu vreau doar să fiu înțeles corect.
I would only like you to understand me the right way. Exercising the rights that I had was not fraudulent in nature. That was not, well, my exercising of those rights was not in violation of the law. And in general, and I also put this down in my answers, that if I had known, I couldn't even imagine that I would ever have any litigation regarding the apartment for about 9 years now. And had I known that there were claimants, people who claimed rights over that apartment, I would have given it up, because it consumed a lot of my time. It consumed a lot of my emotions. The general prosecutor has taken some action with regards to that media report, and then several actions followed and somehow affected my image. And all the stages that I went through, starting with the 2009 decision, then the 2014 decision, and all the other requests and inquiries and applications with the General Department for Housing and the Privatization Commission, all of that I did only because I had the intention, legally supported, while understanding I was not in violation of the law. If any of these courts, at any moment in time, if any of those institutions, at any moment in time, if any of them said, "Sir, you cannot privatize this apartment," or in general, "You cannot be the owner of this apartment, you cannot be the one using this apartment for service purposes, like service housing," if they told me that, maybe I would have given up on it. And everything would have just stopped if any of those institutions had, at any moment in time, said it was not possible. That's why I don't think I did anything that was unethical. I did not pursue any such purpose. I did not have the intention to inflict any harm on anybody. And it was not, I couldn't have. I mean, maybe the Commission is right to say that the provisions of the law are that, but I couldn't have known of the provisions of the law on privatization, because as any other magistrate, prosecutor, or any other magistrate, you cannot know absolutely every law. I knew that I could go to that institution, and if they rejected my application, then I would have looked into the legal framework and come to understand that I was not right and I had to withdraw, or that I could, for instance, challenge the decision of any particular institution. I could have moved on.
I have no further questions on this.
Yeah. Vitalie Codreanu.
Domnule Codreanu,
Mr. Codreanu, I would like to greet you. It is a complex topic. I will try to ask some questions and I will try to be as brief as possible. So, Mr. Codreanu, in the context of your position that you held according to the law on Prosecutor's Office applicable to the period 2008 to 2009, prosecutors like you had the right to service housing. The dwelling code or housing code at that period defined what was service housing. It is a dwelling for some subjects who in the context of their job come to live there. So it was already established and stated that the law on privatization, both back then and now, prohibits privatizing service housing. So in 2009, the state, by the decision of a Court of Appeal, recognized your right to service housing. That decision was not enforced for years because the municipal council did not have apartments to provide the service housing. At least this is what I read in your answers. And I would like to talk here about your actions. In 2014, when you applied to court, I mean Rășcani court, you requested several things. So you identified an apartment and you requested 3 things. To declare vacant succession for that apartment, for that apartment to be transferred to the municipal council, who was the defendant in the decision of 2009, and you requested as a plaintiff to be issued an order of assignment of the apartment. So you had 3 requests and 1 application lodged with the court. My first question, didn't you think it was premature at the stage of filing your application in court to ask already for apartment assignment? Because the lawsuit in 2014 was relying on the decision of 2009, which was about service housing. But as long as the apartment that subsequently was declared vacant was not transferred to the municipal council, which means as a manager of housing stock, it had first to receive it, to give it status of service housing, and only after that to be able to transfer it to you under an assignment order. Do I understand correctly? Probably yes, but I did not know about that procedure. That's what I wanted to ask, because you altogether made 3 requests that were excluding in a way the possibility of a municipal council to give that dwelling a special status. So now I'm asking you, don't you think it was premature to ask for an assignment or apartment assignment order at that stage? Don't you think it was premature? I don't think so, because these actions, well, one action comes after another, and probably I'm just trying to, it's how I feel it. When my lawyer drafted the application, probably he or she did not want for this issue to be examined in several litigations, in several courts. So for it not to take too long, decided to file one single application. Well, so satisfying your application in the way it was submitted excluded the actual possibility for the municipal council to declare this apartment housing, service housing. I did not think about it. Okay, your answer is accepted. Secondly, in your previous answers, you mentioned that all applications were filed as appropriate to the bodies, central and local authorities, and they, in a way, share part of the blame. Well, it's not a blame, it's a duty of theirs that they should have fulfilled. I would like to ask you the following. Once the municipal council was obliged through that irrevocable decision, I mean the decision of 2014 of Rășcani court that became irrevocable in the Supreme Court. Once there was an irrevocable decision, could the municipal council offer you another solution than that apartment assignment order? I think not. Your answer is accepted. Two more very brief issues. The decision of 2014 was appealed and challenged by the Municipal Council and by the Tax Service. Provided that you remember, in the appeals and challenges by the authorities mentioned before, did they mention the argument that actually the reason for the decision of 2014 is the decision of 2009 about service housing? I mean, I'm asking, did they invoke that in 2009 it was the decision was giving you about service housing and not permanent dwelling? I don't know. You don't know. Your answer is accepted. And the last question. In relation to this issue, you mentioned repeatedly that there was a disciplinary control of your person with respect to this. I want to ask you, what was the outcome of that? I submitted to the Commission the decision, if I'm not mistaken, of March 2018, and that service control was performed after that publication, CRAI-MD and Zaudegarde, but I'm not sure which came first. When the Prosecutor General at that point notified the inspection called me, I provided explanations, I provided the documents, the court decision, everything that the lady inspector asked for. And that's it. And I was not called in anymore. By email, I think they sent me the decision, and that's it. And the decision was not appealed by anyone. But I would like to mention that during the litigation related to the litigation under which the decision was issued in December 2022. That litigation started back in 2016 or 2017. I don't remember exactly, but it is a long time. And then the plaintiff's attorney notified the prosecutor's office about starting a proceeding under Article 294. And in relation to this, I was not summoned by anyone. Unfortunately, I don't have that answer because it did not envisage me, and the prosecutor that gave that answer was not competent to inform me as well. But I know that that request was rejected, and from what I know, criminal proceedings did not even start. Only made reference to the fact that this issue was or had been investigated by the prosecutor's inspection, and that it was found that no deviation, that I committed no deviation. Thank you for your answers. Mr. President, I have no more questions. Esteemed candidate, hello. I would like to explain you, for you to understand. Law, particularly civil code, provides for a procedure of how, what's the vacant succession procedure. The first stage, the State Tax Service, is when they establish or find a property or an apartment that is vacant without an owner, no one lives there, notifies the notary. The notary starts a succession procedure, checks if there are any inheritance by law or by will. After that, the notary issues a certificate of vacant succession. Based on that certificate, the property is transferred to the state, and after that it is checked. You are now making reference that you did not know. All the responsibility you push on to the court, authorities, city hall, and so on. Did you understand that part of the responsibility is on your plate now in all these actions that you carried out? I don't know how to explain. As long as I did not act in ill faith or in a fraudulent way towards any of these institutions, because I'm saying this issue involved at least 7 or 10 authorities. First court of appeal. Well, you filed an application with court. You signed it. Is it right? Yes, exactly. When you received the decision of the first court and you saw that it's not about service housing, did you appeal the first court level? Should I appeal my own application that was accepted? No. I don't think there is such a situation in judicial practice. When a person asks something from an authority, the authority accepts that application integrally, and then the person challenges it? Well, you had the right to service housing. I understand, but as a result of these manipulations, or how we can call them, you became the owner of a real estate permanently. It became a property. I cannot say that's manipulation because I would offend the ones who examine the proceedings, but 3 courts, including Supreme Court of Justice, State Tax Service that had the minutes and transferred that property and transferred it to the City Hall. The City Hall through the Housing Department, that's another authority. Privatization Committee, all these stages. Do I see that part of the guilt is mine or part of this problem? Thank you.
A few questions on top of what has been already extensively discussed. So if I get it right, so when in 2014, I think it is, you started submitting a request for the to declare the apartment for you. At that time, I think the size of the apartment and the status of the apartment was already known to you. You had a young child, your wife did not want to go there, and this was all in the context of for you to get a service apartment. Service apartment, I think, means service as you as a prosecutor. How would you continue having that whole procedure focused on this service apartment if it would never service you as a prosecutor?
I cannot agree with you because over the years I changed the window. Now I'm preparing to repair it. I will live in that apartment because where I live now, I live with my parents. And for this reason, there are certain inconveniences. So it would be better for me to live in that apartment, and we recently started repair works because, well, financially I couldn't afford it before. Secondly, I had the litigation, and I still have the litigation. In other words, I could have moved into that apartment from the day it was evicted and free if that apartment had the minimum requirements to live there. It doesn't have any warm hot water, it's disconnected from the network. It mold in all the rooms, and it's not something very light. I am telling you, it was impossible to live there.
But in addition to that, when in 2016 it was privatized in the name of your wife and your daughter, would it have been possible for you to purchase the apartment if also your name would have been in a contract? In other words, if your name would have been in there, would have been no privatization, and would you not have become the owner at all, or would you simply have had to pay a higher price for the apartment?
No, that price was regardless of whether I was included or not. That price was established by the commissioner, by the City Hall. I actually don't know who established the price, and that's what I paid as established by the City Hall. I don't know what would happen if something happened, or what fee was, what would be the price in the sale purchase contract. It's not up for me to decide. I was given the contract. I accepted the conditions, the terms of the contract. I went to the notary who authenticated actually that transaction. I paid all the charges, and that's all.
But the apartment wasn't meant to be a service apartment for you, but your name is deliberately not included in the contracts. Is it correct?
Nu pot fi de acord.
I disagree. Again, it's not about the intent. My name was not mentioned in that apartment, talking about privatization, because I could not be part of a privatization, because previously, in the 1993, 4, 5, my parents included me in the privatization. And privatization of another apartment was impossible. And for this reason, we decided that my wife, who did not have any privatized good by the time of 2015, to have her privatized together with the child. And the Commission didn't ask for any other documents, like the document regarding my participation in privatization was submitted. I submitted it to the Commission at their request. I don't know if the Commission took that into account or not. Did it believe that it was necessary to draft a sale purchase contract in a certain form? I don't know. They called me, please come and get your contract, sign it, and get it to the notary. This is what I did, and I paid all the payments that I had to. But this apartment, your parents' apartment, where you said that in the 90s you're part of it, you had 1/4 of that apartment. What's its status now? What's happening to that apartment? It's a private property of our family. We are all living. So until now, you are the owner of 1/4 of that apartment. Where is it located? Chocana. I said that. Okay, 1/4. So it was privatized in 1994 when you were a child. You're saying, yes, exactly. But my wife did not have anything privatized, and she did not have a real estate where she could live, neither did my child. And I could not keep living with my parents, like two parents, my sister, my child, and myself. So when you requested service housing, you were already owner of 1/4 of that apartment. In 2009, obviously, since 1994 I was, but I could not, in 2009, I could not live in that apartment together with my parents. Given that law allowed, I wanted to live alone in an apartment, to be able to create a family and to have some separate property, and my family to be separate from my parents. And I think it is an absolutely normal and logical intention on my side. It's not with ethical issues. So. Microphone, please, Herman. I can't hear.
Please go ahead, Victoria, for the next issue.
Yes, the next issue I'm going to ask you about is the use of a preferential housing program for prosecutors to assist the purchase of a property for a family member. I'll read you some facts and then ask you some questions. By virtue of an investment contract you signed dated 15 May 2008 and registered on 22 December 2010, you became the owner of record of a 65.3 square meter apartment located in Chisinau, and that was based on your position as a prosecutor. The apartment was purchased at a price below market price through a program for prosecutors who needed housing to obtain housing at a preferential price. The building in which the apartment was located was built for prosecutors and employees of the prosecutor's office. According to your answers to the commission, to questions from the commission, de facto you have never been the owner of the apartment. The apartment was paid for by your parents and was meant from the very beginning for your sister and her daughter. Once your parents decided to purchase the apartment for your sister, you requested the Prosecutor General's office to include you in the list of applicants to purchase an apartment. You stated that you had no link to the apartment and that you never lived in it. In 2013, you signed a sale purchase contract which purported to sell the apartment to your sister. The sale purchase contract indicates the sales price of the apartment was 408,671 lei. However, no funds were paid as a part of the transfer of the apartment to your sister. I will begin by asking you some questions to establish the facts, and later I'll ask you some questions that will seek greater detail or explanations from you. Please confirm that you signed an investment contract dated 15 May 2008 that was registered on 22 December 2010, by which you became the owner of record of a 65.3-acre apartment located in Chisinau, based on your position as a prosecutor. The apartment was purchased at a price below market price through a program for prosecutors who needed to improve their living conditions to obtain housing at a preferential price. The building was built for prosecutors and employees of the prosecutor's office.
Este adevărat.
That's true.
Please also confirm that de facto you have never been the owner of the apartment. The apartment was paid for by your parents and was meant from the very beginning for your sister and her daughter. You did not have income that would let you purchase such an apartment at the price of $447,202 lei. You stated that you had no link to the apartment and that you never lived in it.
Exact.
Exactly.
Please confirm that once your parents decided to purchase the apartment for your sister, you requested the Prosecutor General's office to include you in the list of applications to purchase the apartment.
I confirm that.
At the time when you applied to the Prosecutor General's office to include you in the list of applicants for preferential priced housing, you had no intention of buying the apartment for yourself and applied so that your parents could purchase the apartment for your sister.
Este exact.
That's exact.
If the apartment was being purchased for your sister, why wasn't the contract made in her name rather than in your name?
De ce e că acest program beneficiau
Because that program was only for prosecutors and prosecutor office employees, and my sister was not employed at that time, and she could not be part, de facto or de jure, she could not part, the private, the committee within the prosecutor's office, general prosecutor's office, could not accept such a request from a person who has no connection with the prosecutor's office activity.
And is that the same reason why the property was not registered in her name and why it was registered in your name?
Da.
Yes, yes.
Did you inform the Prosecutor General's office that you were not seeking housing for yourself, but that it was being purchased by your parents for your sister?
No, I did not inform the General Prosecutor's Office, and they did not ask for any other information. For them, it was not important what was the further purpose of the department, and I tried to send to request for documents from the General Prosecutor's Office, and I was told that these documents are not there anymore, and I submitted the Commission the proof of my request.
In 2013, you signed a sale purchase contract that purported to sell the apartment to your sister. The sale purchase contract indicated the sales price of the apartment was 408,671 lei. However, no funds were paid as a part of the transfer of the apartment to your sister. Is that correct?
Exact.
Exactly.
So the sale purchase contract did not accurately reflect the terms of the transfer of the property to your sister, correct?
Erau
These conditions
doar prin
were
cumpărare care
only through the sale purchase that I believe was simulated.
și aici îmi fac referință
And I will make reference to provisions of Article 1089, 1090, and I would like to address this issue from this perspective, meaning that since my parents and I was living, and my sister and I were living together, we were living together and having common budget. This matter was solved in the family. And in order to be able since my sister had a small child, and for her to be able to live separately, because it was quite complicated, it was decided, since I benefited of that right to a preferential price, it was decided that I requested to be part of that that type of transaction, sale-purchase transaction. In connection to Commission's question, I studied the legal framework regarding this, and I found that this simulation that I am mentioning, saying that the sale-purchase contract from concluded between me and my sister, aimed at her becoming the owner, because she was the de facto beneficiary, the beneficial owner of this apartment. And I made the comment that in 2013, when I got married, that's when that question was raised by the sister, given that family and marriage can generate certain property issues, decided that the sister should be the legal owner of the apartment. And when I talk about the simulated contract, the legislation of the Republic of Moldova previously declared void the fictitious contracts. Now, this notion doesn't exist anymore. There is a notion of simulated contract, and the law actually provides for the possibility to conclude such contracts, and such contracts don't make the contract and legal report void under certain circumstances, and I believe that my sister and I met those requirements or conditions. So the absolute nullity that is about violating a law or certain provisions of a law, especially of the civil code, causing prejudice to third parties, or acting in circumstances of with ill intent, including acting by crime. All these circumstances in case of these two contracts did not happen. And that's why I believe, again, if you ask a question about ethics, I believe that these two contracts are perfectly legal. And there were no objections so far, and they generate effect now. Both legislation and legal doctrine provide for the possibility to conclude and for existence and the recognition of authorities by recognition by authorities of such contracts. I did not cause prejudice to anyone. I did not harm anyone's interest. I did not act to the detriment of anyone, to the detriment of a third party. Because, and I believe that the Commissioner will ask me, but other state authorities could invoke certain payments. No, they could not invoke any payments because my parents paid for that contract for my sister. We did not have a purpose, neither my sister nor I. When we had the sale purchase, we did not have a purpose of making profit out of that contract. And the purpose was just to have a ownership right registered at the cadastral office on my sister's name, given that, well, because this apartment was meant for her from the very beginning.
Just use a donation contract to transfer the property to her?
I don't know. Maybe that was another possibility to alienate that apartment. When we went to the notary, we asked him what would be the optimal action for us all, including for the notary, in order not to fall under another provisions of another law or not to have this contract. And the notary said it's not an issue to draft a sale purchase contract. I could not have donated it. I did not have the money. I did not have such funds to be able to donate to my sister or show somehow that actually I was the owner of the apartment.
But you were the legal owner of the property. The property was registered in your name, correct?
Yes, but it's as you said that there is an agreement, that contract that was registered with the cadastre under my name, and the sale and purchase agreement, and this final handover document from the construction company that built it and then handed it over to us. So in that regard, there were no questions about the apartment. Nobody asked about it, as in, for instance, Bascons Lux, the construction company. They did not care who the owner is, who the owner was, who was buying that apartment. And the commission also did not ask about the final purpose. In fact, nobody cared about it. Nobody showed interest in it.
Please confirm that you did not disclose the apartment on your 2012 annual declaration to NIA?
I explained in the first round of questions and answers that, well, at that time when the round of questions came in, I asked NIA for all the declarations I've submitted to that declaration. It used to be called the Commission, the National Integrity Commission, the NIC. And they provided those documents to me, and I saw that indeed that apartment was not there. And I explained in my answers to the Commission why I did not report that apartment and how that omission can be explained. And I would like to reiterate that I did not have the intention to hide that transaction away. I did not have the intention to hide that asset away. Same as I did not have any intention to hide away the property where I was living with my parents, the asset or that apartment that is in Chokana City District that I was asked about today. In the 2012 declaration, you will not see any asset. I did not put down any asset there, which means logically, I was living somewhere, and the Commission could ask me why didn't I specify that other asset on the Mircea cel Bătrân Street. And my explanation to this is that back then in 2012, those were our first attempts to file asset declarations. So back in that time, the format was not clear, and in general, we would introduce the information there by hand. We were writing it in, so we didn't know what exactly we need to write down there. So at that time, it was the first time experience. I thought it's one declaration that you submit one time in one that version. There was no one to consult with. There was no one to ask. Now we have access to the integrity agency. You can call them. You can ask questions. You can have any question answered by them. They are very responsive. But I had no one to ask at that time. And in our group of prosecutors, as we were at the General Prosecutor's Office at that time, I then believed that we only had to include the real estate that we have acquired. In that year, in 2012, not that we have been having, that we had from earlier years. Why did that mistake happen? Because you see, I did not even put down, not even that apartment where I was living in. That apartment of my parents where I was living with them and where I had the right to a fourth of that asset, I did not indicate it in that declaration, and I did not do it purposefully. It happened because of not knowing, because it was a first-time experience of that kind.
Can I ask you to look at your 2012 declaration? And I think we furnished a copy of it to you in your materials.
Imediat îl găsesc.
Give me a second, please.
2012, da.
So, 2012, we're speaking about the 2012 declaration.
And if you could turn to the third page, it's second page actually, in subpart 2, immovable property. And I believe there that you listed
Da.
2 properties that were purchased in 2010.
Da, este indicat în dobândire.
Yes, it says that the year that was a donation from my mother.
So those were properties that you had acquired before 2012, correct?
Da.
And you still declared them in your 2012 declaration.
Da, eu le declar.
I declared those assets. And the question of the commission is?
I was just confirming that you did declare property that you had acquired before
Da, ele
2012
sunt menționate.
in your
Ele sunt
2012 declaration.
That is correct.
Okay. You were asked by the commission in written questions whether you considered it ethical that you benefited from an apartment at a preferential price as a prosecutor, knowing that the real beneficiary of the apartment were your parents and your sister. You stated that you believed you hadn't violated the ethics of the prosecutor's office, and that you hadn't prejudiced the rights or interests of any other people, and it was an issue addressed within your family and not pursuing a profit or other petty goals. And that's what you informed the commission, correct?
Da, exact.
Precisely.
But the preferential price program that you applied for provided housing for prosecutors who needed housing, correct?
Da, exact.
Yes.
And your sister was not a prosecutor or an employee of a prosecutor's office, correct?
Nu.
No, she was not.
Okay. And your parents were able to buy your sister an apartment at a reduced price only because you applied to the program, correct?
Exact.
Exactly.
And with one apartment going to your sister, that means there was one less apartment available to a prosecutor who needed housing, correct?
Not because all those who have access, all those who applied to that program, they all received an apartment.
So no one was denied housing.
Nimănui n-a fost refuzat.
No one was denied housing. Only they were denied only with regards. So some applications were rejected because of the size, the footage of the apartment. So those who were not married would have a one-room apartment. Those who were married had children. They could have larger apartments, 2 or 3-room apartments. So those were some maybe decisions of the commission at some point that could have maybe rejected, and the prosecutors, people might have not been happy with it. But in general, all those who applied for apartments, they all received it, and there were even more apartments left because that particular block had more than 600 or 700 apartments. So that is actually some sort of a neighborhood, like quite large. And from that number of apartments, many of those apartments, as far as I know, I don't have official information that I could confirm though, but as far as I know, many of those apartments were left to that construction company that built that apartment block. So that company was left with some leftover apartments, let's put it like that. And all the applications filed with the program were accepted, and all those who applied got their apartments.
But your sister got it at a preferential price, correct?
I got it. Yes, but then she was the one who was the beneficiary of that apartment. That is correct. And I would like to tell you that partially so you could say she partially benefited from a preferential price because in that particular situation there was an exchange of locations. As in, that particular neighborhood I was telling you about is in the center of Chisinau. And those apartments, I did not receive an apartment in one of those apartment blocks, but I asked the company, the construction company, I'm not sure if I raised this with the commission too, but I asked that the apartment from the central block would be actually replaced for another one, for another apartment in Ciocana. So this sort of a replacement exchange rather, because all the family was living in Ciocana, myself and my parents. There was an apartment that was also there's another apartment block built also by Vasconcelos construction company, was close to where we were living in Ciocana, like about 300 meters away. And therefore, I was given an apartment with 50 square meters for a preferential price, but Vasconcelos in the Ciocana apartment block didn't have apartments with that number of square meters. So they suggested us to buy one that was 66 or 67 square meters. And the price, that difference in price between the 50 and 67 square meters, so the 17 square meters, the parents paid for that difference at the market commercial price. Because Vasconcelos accepted for this exchange, for this inversion, so to speak. So I could say that I did benefit from this partial preferential price program, but not to the full extent, because still about 17 meters of the apartments, square meters of the apartments, they were paid for at the market price for about 600-700 euros per square meter. So that's why there's that difference in price. In the contract, there was a contract that I entered in with Vasconcelos, and there's a different price compared to the price that was specified in the contract with my sister.
But you didn't benefit from the price because you weren't paying for this apartment, correct? Your parents benefited from the reduction in price.
Yes, well, I keep saying that it's my parents who paid for it, who bought it. I did not have that amount of money. I did not have the revenue income such as to afford to buy such an apartment. And out of all of those who purchased apartments, I can speak for myself. I don't know how other people bought them, but I did not have the possibility using my own funds, using my own income. I was not able to afford. Although my income, same as the sources of my parents, I believe, because we lived in the same place, and my parents, somehow, one way or another, they would somehow support all of us. They would provide for all of us. We would eat together. We lived together. I don't know how to put it. The household expenses, most of the expenses, it was the parents and myself covering that, but the money specifically belonged to the parents.
Okay, is there anything else you'd like to add or clarify with respect to this issue?
No, mulțumesc, no.
Nothing else, thank you.
All right, and I'd like to move to what is our last issue, having to do with the source of funds for automobiles and ownership of automobiles. It's the Commission's understanding that you don't own a vehicle, and between 2013 and 2015, 3 cars were purchased and registered in your father's name. In 2003, a Nissan Patrol model year 2005 was purchased for 10,500 euros. You registered a right to use the vehicle in 2013 and paid for insurance on the vehicle from 2014 through 2022. In 2013, on March 20th, the Land Rover Defender model year 1997 was purchased for $5,000 and registered in your father's name. You registered a right to use the vehicle in 2013 and paid for insurance on the vehicle from 2013 to 2015. In 2015, on March 20th, a Hyundai i20 model year 2013 was purchased for 7,200 euros and registered in your father's name. You registered a right to use the vehicle slightly more than a month later on May 5th Your wife registered a right to use the vehicle on June 17th. You paid for insurance on the vehicle from 2015 through 2022. When asked about the source of income for your father to purchase the two vehicles in 2013, you cited his salary of approximately 64,000 lei per year and indicated 1,261,670 lei total between 1999 and 2013. You also cited income from honey sales from beekeeping, which you indicated was 100,000 to 200,000 lei per year. In response to further questions from the Commission, you indicated that between 2000 and 2013, your parents had 1 million lei in income and savings. You also stated that between 2007 and 2010, your father received the equivalent of 7,000 to 9,000 US dollars as dividends as an employee and shareholder of a company he had worked for. The total purchase price of the vehicles purchased in 2013 was 332,630 lei. In addition to these vehicles, your parents purchased the apartment for your sister in 2008 for 408,671 lei. Total cost of these purchases was 741,301 lei. Please confirm that you don't own a vehicle, and between 2013 and 2015, 3 cars were purchased and registered in your father's name.
Exact.
Exactly. I can only use them. I only have the right to use them, 2 of them. There used to be a third one, but that mandate was canceled by my father.
Okay, in 2013, the Nissan Patrol was purchased for 10,500 euros, and you registered a right to use the vehicle in 2013 and paid for insurance on the vehicle from 2014 to 2022. Is that correct?
I guess so, and I can't remember very well, and the Commission did not raise questions, did not ask any questions regarding the insurance for me to be able to prepare for that and obtain the documentation, I guess so, but I do not exclude the fact that it could have been my father doing it, making those payments.
Making the insurance payments?
Yes, I do not exclude it was that. It is likely that it was my father, because initially he was the one driving that car, the Hyundai. Nissan was not in a good condition, was deteriorated, and he would only drive it once in a while, only especially if he had to, since he was engaged in beekeeping, he would have to go to drive into the forest, for instance, and sometimes he would take that car when he needed to carry something heavy. When he was traveling to the hives, he was sometimes using it.
As to the Nissan Patrol, do I understand that you did not pay for insurance on that vehicle from 2014 to 2022?
No, eu am achitat.
No, I did pay. I certainly paid insurance. I just don't know certainly what were the years. And when was it, when I paid and when my father paid for insurance, I'm not sure. It is likely that in the first years it was him, or maybe me. I am not sure about this. Because as I said, I was not asked about this insurance payments by the Commission, and I was thus not able to seek this information from the insurance company, so I can't provide now a concrete answer.
Furnish the insurance information to you in discovery, in the materials that were furnished in discovery.
Eu nu le-am văzut.
I did not see that. Speaking about insurance, I did not see that in the discovery file. At least it didn't come across them. I did not see that. But I would like to mention that I received the discovery, the materials, on the 19th or the 20th? No, 20th. No, the 19th. Oh, it's on the 19th that I gained access to the materials. Or the 19th or the 20th. I didn't even have the time to really then check on certain pieces of information, but since there was no question specifically about it, I was not even ready for an issue to be raised about it and then to have to answer it.
So in 2013, on March 20th, a Land Rover Defender was purchased in your father's name for $5,000 and registered in his name. And you registered a right to use the vehicle in 2013. And our records also that we have indicate that you paid for insurance on the vehicle from 2013 to 2015. But you're not able to indicate whether that's correct?
Eu nu pot să spun
I cannot say for what cars I was paying insurance for and when was the period I was paying insurance and for what cars. It's not always that I had access to these cars. I would temporarily and sometimes particularly I could use them, but when he needed them, I mean these two cars, that are like off-road vehicles. He needed them for his work, as regards his work in beekeeping, I mean, so that's why they were even bought. He was supposed to be able to carry heavy items. He was supposed to be able to travel in terrain conditions that are hard to travel to in a simpler, smaller car. So he needed more of an off-road vehicle. So he would use one car and then a different car depending on what he needed the car for. Or he would, for instance, travel with a number of people, as in he could use two cars, as in he would drive a car and I would drive a different car, and we would have people in each of these cars, and we would bigger number of people would travel to a particular destination. Because there were people who would help us with extraction of honey, all things related to beekeeping.
You used the vehicle in 2013, and are you able to confirm that you purchased insurance for the vehicle?
Well, I can't say precisely now. I would like to reiterate that I don't have that documentation now to look into, to answer that precisely. I was not asked about it for me to be able to look into it and now to provide a clear explanation. It's not excluded that I did, but it's myself or my father who paid for the insurance.
In 2015, on March 20th, a Hyundai i20 was purchased for €7,200 and registered in your father's name. You registered a right to use the vehicle slightly more than a month later on May 5th. Your wife registered a right to use the vehicle on June 17th. And our records indicate that you paid for insurance on the vehicle from 2015 to 2022. What of that information can you confirm?
Again, this time around too, I cannot provide a very clear-cut answer. As regards this car, it has been used by my father, by my wife, so the insurance could have been paid by my wife too. It's not excluded, because starting with 2021, that car was rented out to the lawyer's office, and maybe it was the wife who paid for it. I didn't have a question about it. Just I would like you to get me right. For all the questions that the Commission asked me about, for all those questions, I sought more information from the authorities, from the relevant authorities. I think I've already filed about 15, 20 requests to other institutions. And for every question I wanted to, and I tried to do my best to provide clear confirmations, even in those situations where, speaking about the cars issue, I wrote a request with the vehicle registration department, and they said that they were not keeping. I mean, the Commission asked me about it, whether I could provide any supporting documentation, as in I was asked to provide supporting documentation, and I filed a request with that vehicle registration department, and they said that, considering that I am not a legal heir, or I don't have a document on succession, so to speak, on inheritance, they were not able to provide that information to me. But they told me that when it comes to sale and purchase documentation for those cars, that they are not kept for longer than 5 or 6 years. So in a way, they told me that they sort of didn't have that documentation. Regardless, I looked for that documentation, and I found a few of them. There's a receipt that shows who paid and what amount was paid. there is a sale and purchase agreement with Maib Leasing, and then there were also some payment orders that were also drawn up and signed by my father, which is proof of the fact that he was the one who paid the amount of 7,200 euros. And with regards to the other car, I don't know where he bought it from, because with regards to this car, the Land Rover Defender, what I was told about it, that he bought it, that he intended to buy it for $5,000 or 5,000 euros. And I don't know where I can look for this information, where to find this purchase and sale and purchase agreement to give it to the Commission and to make it clear who the actual owner of those cars was.
When asked about the source of income for your father to purchase the vehicles in 2013 and 2015, you cited his salary, again, 64,000 euros approximately, 1,261,670 lei between 1999 and 2013. Income from beekeeping, which you estimated to be 100 to 200,000 per year, and the only documentation that you were able to provide about the income from beekeeping was sales in 2019 and 2021 totaling 105,592 lei, correct?
Correct, but it's only one thing that I would like to clarify in this regard, and it's specifically that all of these estimations regarding the income of my father from his beekeeping work, that is approximated income. I cannot and actually tried to submit to the Commission some sort of documentation ascertaining the fact that my father was a beekeeper and when he started to get engaged in this business, and that was also confirmed by a certificate that I provided dated from 1991 and up to when he passed away in 2022. And I've also submitted, and I would like the Commission to take this into account, that in fact these are my key arguments. My father owned and had about 100 up to 150 bee families. And in this regard, I also provided a certificate, a document of the beehives. It's chosen in 2011. He had in his ownership about 130 bee families. And I've made some calculations with regards to the quantity of honey and honey products, and then it is also relative. Up to a particular age, I was also participating in everything related to the bee keeping activity and to extracting the honey, and as far as I can remember, because I think I was also, a minor back then, I provided that information, but based on some approximation. But also I provided information that was valid for 2021, 2022, that shows that my father sold to a business operator a ton for 100,000 lei, 105,000 lei. I wanted to show that my father was actually practicing it. It was an actual, real income-earning activity, profit-yielding activity. And our family, before I got married, after I got married, but before that as well, we were being provided for on the basis of that income earned from beekeeping. And depending on the different years, the quantities would be different. In a year, we'd have more honey and then less honey. And in a different year, it would depend from year to year. But it would be at least a ton, up to 5 tons, and even more sometimes. And in this regard, I also tried to explain the Commission and to show some reference prices for honey products. And I wrote a request with the National Bureau of Statistics, and I was given this information, the prices for every separate year, but they were not able to answer about the sale purchase, how much a bee family cost, because my father engaged in that as well. And he was selling bee families, and he was also selling wax and pollen, propolis. These are actually honey-based products that are quite expensive. I'm not sure I mentioned this, but 1 gram of propolis costs about a few hundred lei. That was a very expensive product. Small quantities, but very expensive. And for these products, there were always people looking for them. They were always in demand. The idea is that these calculations that I made These calculations that I made based on the sale of honey, the 100 to 100,000 lei a year, they were only based on the sale of honey alone. And in many years, when honey, we wouldn't manage to sell honey because all the other products were being sold very fast, they would be stockpiling, so to speak, a year after another, because you could keep them for a long time. And when my father was not able to store it anymore and didn't have any place to store it, he would sell it wholesale.
The amount of 100 to 200,000 is a starting point, we could say. It's not fixed like 100,000 per year. It could have been 150,000, 200,000, 250,000. It is that I did not know, and I never talked to my father about the income he had. He did not say, and I did not ask. Even when I was preparing the answer for this question round, I was asked if I knew about my father's income. I only said an approximate. Maybe my father had other income too. I mean, and for the commission to know, I found an income of $7,000 or $8,000 that I made reference to in the answer. And from several institutions, I asked for information. The single depository that is keeping all the shares of all the joint stock companies informed me that my father held shares of a company, but it could not provide me information about the $7,000 or $8,000 dividends. I asked information from the company where he worked and where he had shares. I asked for information from the National Commission for the Financial Market. They could not answer either, but in relation to this situation, I found and I discussed with former employees of a company who confirmed that they received amounts. It is about Aceto company. They received amounts that ranged from $4,000 to $30,000, depending on their seniority. In 2007, when the package was sold by the Australian company, the employees got those amounts. Now I made a request to Bank, where the company Aceto had its account, and probably that's where my father got the money. So yesterday I received the answer from Aceto, and so yesterday I made a request towards Moldova Bank, and today they called me. They cannot provide me this information because it is a bank secrecy thing, and they cannot give me this information.
Produced from the company indicates that there were no dividends paid to your father between 2007 and 2010.
That is not true. That document says that since 2009 until today, or until 2022, until his death, he did not receive, or such dividends were not issued, but the money was received not in 2009 but in 2007, and I believe that the money was offered not as dividend for holding the shares, but in relation, or I believe it was sort of an indemnity that all employees received when the company was sold by the mother company in Australia. And I would like to kindly ask the Commission, if possible, before you pass the decision, taking into account provisions of Law 26, to make a request towards Moldova Agrarian Bank and obtain that information, because I believe that this information is absolutely relevant and important for me, and I think for the Commission as well, for me to be able to justify what was the income of my father, including in 2007, and that will answer the question of the Commission that asked me about 2007 to 2013, how I can justify my father's income.
And we've produced state fiscal service records for your father from 2007 to 2010, which don't indicate any income to your father from dividends paid by the company. Were you able to review those documents?
Yes, I saw those documents, and indeed the tax authority gave only information about his salary.
Okay, so is it still your position that in 2007, just so we have the tally correct,
În 2007, sigur.
Yes, in 2007, my father certainly received that amount. That is a certain deed, because this was discussed in the family, and my father told us that this money comes from Aceto company. Under what circumstances? How did he receive that money? I don't remember. Probably he did not explain it to us at that time, because this is a procedure that is not related to salaries. It is not a procedure related to the relationship between employee and employer.
Just want to confirm that in response to further questions from the Commission, you indicated that between 2000 and 2013, your parents had roughly $1 million lei in income and savings, correct?
Peste 1 milion.
It was over 1 million, and I would like to remark that I submitted to the Commission the information I requested from the from CNAS, that's the National House for Social Insurance, and they did not have all the records starting from 1991 or 92 since I asked. They provided me information only as of 1999 and until his death. And that amount, until 2013, the salary that he received was over 1.2 million lei, plus since 2013 until 2022, I think. He also received a pension, total amount of over 400,000. Moreover, I provided the Commission the documents proving that he, after he retired, after he resigned, he continued to provide services. So he was not employed, but he worked based on the service provision contract. And in those contracts, the Commission noticed, they show the amount and even the payments, like 30,000 lei or like salaries or 0.7% of the income of the company. I could not get a precise answer from them because their archives have been liquidated, but I submitted the document coming from Aceto. I believe the amounts were much over 1 million lei only from salaries and pension, not even to mention his activity that brought most profit to our company.
Okay. So the total purchase price of the vehicles purchased in 2013 and 2015 was 332,630 lei. In addition to the vehicles, your parents purchased the apartment for your sister in 2008 for 408,671 lei, and actually maybe more. The total cost of these purchases was at least 740,000, which which was almost 3/4 of your parents' savings that time.
Well, speaking of the savings coming from salaries, you are probably right, but I reiterate that is very important. The main income was from beekeeping, and this income was about 100,000 to 200,000 lei per year. If we do a simple math, I'm not speaking about 1991, but let's take 2000 until 2013, when these big procurements took place. Based on mathematical deduction, I get to the amount of 1.5 million or even over 2 million lei only from selling honey. Reiterate, only from selling honey. But that was one of the many products that my father was selling. And I, by the way, I'd like to mention that I provided you a price of a beehive during to 2009 or 2010 was about 800 or 900 lei. He was selling yearly tens of bee families. He was making them and selling them. Moreover, I tried to find other income that he officially had. But as I said, that I mentioned to the Commission, my father was not subject of an entity, or he was not a reporting subject of the income he got from beekeeping. And I told the Commission, and I'd like to draw your attention, that I made reference to data about my mother, who was selling honey, and to this end I provided you a document proving that they sold honey since 1994 in a center, and until today, even though my father has died, we still have certain quantities of honey that is being sold. The honey was enough for my father to be able to maintain us all. Well, but I already, when I got employed, I was financially maintaining myself, and my sister did so the same. So he had the means to generate, to gather all this. So if, together with salaries and everything, his income easily reaches 3 million lei in 15-20 years. 3-4 million lei. This is certain.
Let me just ask you, did you or anyone acting on your behalf contribute any funds towards the purchase of any of the vehicles?
No, never. Anyone contributed. All this money were paid by my father. In one case, this money was paid by my father in my presence. In other cases, I don't know. I communicated that in case of the first car, Land Rover, I did not even know that he bought it. Like all the time, he said that I have purchased it. What do you think about it?
So you deny being the de facto owner of any of the vehicles?
I deny categorically. I always use these cars. But I have not been the owner. And I would like to provide some more details. My father was sometimes withdrawing the possibility to drive one or another of his cars, or I was refusing and bringing the car to him, giving him the key, and had nothing to do with that car. I mean, 2013 to 2015, because later on we had the car purchased in 2015. And my father was saying me the following thing: if you want to use this car, pay for it. Pay what you consume, its technical maintenance, insurance, and, well, being well educated and having a possibility from the salary that I received, I managed to cover these expenses because they were not too large. I was doing it, and I was using the car. Then, when my father had health issues, then I was regularly using that car, and there was no more question about is it only me using or only him using. I was. Currently, we are drafting all the inheritance documents. We will see what will be decided by my mother. Because that's how things will be.
Anything else you wish to add to clarify this issue?
No.
No.
So, that since there are no other questions, I would now like to give you the opportunity to make a brief closing statement at the end of this hearing. So please go ahead.
It is for the first time when I take part in such an activity that is quite complicated in my view. And as a prosecutor with not such a long working experience, but I would like to tell you that I carried out an investigation about my family, about all my family members, in order to be able to prove things. I did it sincerely. I try to be proactive. I try to be open. I try to offer as much information as I can for the Commission to understand. I have no ill intent. I never acted illegally. I did not cause damage to any people. And always I have been brought up like that, and that was my work, to always be tactful, to act in good faith. And it was quite complicated, you know, this period was quite stressful. I was always looking for some documents. I always making requests, even by phone, and asking various people, individuals, legal entities, authorities, to give me answers as soon as possible, as urgently as possible. I don't know if you have requests, but possibly to be able to prove that I did not get answers. I provided the request in order to see, to explain why I don't fit in the timeline set by the Commission. But please understand me correctly. I don't have any objection to the timeline set by the Commission. Just I want you to understand that the timelines were very tight for me to be able to search for and submit the information. The timelines were like 2 days or 1 day. Like I would receive the question out on Friday, Saturday, Sunday. That were days that count, and next day or on Wednesday I had to submit the information. This is not an objection. This is just a thing that I want to show. I try to be as fast as possible in these matters. Often, instead of handling my job during the time I had in between meetings, I was writing requests. I wrote a big journal about this. I was calling people. People were referring me to other people. This was quite cumbersome, but everything I submitted to the Commission, and from this entire folder that I received at my request, 80%, maybe less, is what documents that I submitted. And I want the Commission to understand that I am not hiding anything, and I submitted everything I had. Maybe if in some respects I wasn't clear enough or explicit enough, well, I don't know, I could provide some more information, and I still keep my request. And please take this into account, because only the Commission can obtain that information about Moldova Agrarian Bank. I informed you, and I reiterate, even today I talked to the lawyer from Moldova Agrarian Bank, who informed me, like, with all due respect, Mr. Prosecutor, but this information cannot be shared with you, and in many institutions, or some institutions, refuse to give information because my father is deceased, and I don't have an inheritance act yet that would allow me to go to them and ask for the information and for them to give me the information. And that's why I am, and I would be grateful to the Commission, especially that amount, about $7,000-8,000, if that amount would be identified and the Commission to take it into account, because it is absolutely relevant and important to prove that my father in 2007 received that money. And I am firmly stating that I saw the money. I know that the Commission can summon certain people to confirm certain circumstances, to make statements, such as a witness, for instance. I was thinking about that, about such an option, to bring people who are former employees of the insurance company, the head of legal department and the chief accountant of the company, who would confirm in front of the Commission that this money was allocated for most or for all employees of a company. And these amounts were quite large, from 4,000, for example, head of legal department of Aceto received at that time a small amount. Someone received a big amount. There were amounts of up to $30,000, very substantial amounts. What was the criteria based on which they allocated amounts? I'd like to know. I would like that information to be part of the materials of the Commission, and so that a correct and objective decision would be issued, and for me not to have objections about it. But, well, it will be as it will be, depending on your decision, I will decide what I do next. Thank you very much, and if you have any more questions, I am available to answer. Anyway, thank you very much. If there are no more questions, I wish you a good day ahead. And maybe because of being overwhelmed, I was a bit shy. Maybe I was not giving the most suitable answers, and also the video recording. And you know, we prosecutors are not very fond of video recording, but well, in our works, they are a part and more part of our work. We have to be present and relate to the society and media. Thank you very much. I hope I was correct and I was understood correctly. That's it. Thank you.
Thank you very much. And with this, with your closing statement, we come to the end of the hearing. I thank you for all your submissions and answers to the question that we had, both in writing and also today during the hearing. As you are aware, the Commission will now withdraw for deliberations, and as much as possible, the Commission will strive at delivering a decision within a month after the date of this hearing. Thanks again for your presence over here today, and this hearing is hereby now closed. Thank you.